Well, hello everyone, and thank you for joining me today for our webinar on the Medicaid maze, how to navigate it and protect your assets from Medicaid spend down. My name is Lynn St. Louis, and I'm an estate planning and elder law attorney at ELG Estate Planning. We have offices in Spokane, Tri-Cities, and in Seattle. So thank you for joining me today. If you have any questions, please put them in the chat. I'll try to answer the questions before we're done. And we are going to jump right in with Medicaid. Now, Medicaid is a pretty complicated area, and I am going to do my best to break things down so that they are understandable. One of my goals as the founder of Elder Law Group, ELG Estate Planning, is to make knowledge about estate planning and elder law accessible to you so that you can use it for your benefit to protect yourself, your family, and your money. So that is my goal. So long-term care costs. When we're talking about Medicaid and how to protect your money from Medicaid and Medicaid spend down, why are we having that conversation? That conversation is because we are talking about long-term care costs. And if you are like the majority of people, you've had some experience with Medicaid or with long-term care costs, not necessarily with Medicaid. Long-term care expenses can be $10,000 a month, can be up to $15,000 a month, and that is a lot of money for most people. And what often happens is people, when they are facing long-term care, they don't know what to do. They don't know who to turn to. And that is the reason that I am here providing this information to you. So we're not going to just talk about protecting your money. We're going to talk about other resources that might be available to you. So how do you pay for long-term care? Most people pay for it out of their savings, their own money, until they become impoverished. And that is something that I hope we will help with today so that you see that there are other options. Other ways that people pay are from long-term care insurance. If you have that, fantastic. Keep it in place. Do not let it lapse because the premium increased. That's what the insurance company wants you to do. Keep your long-term care insurance policy in place and pay those premiums. I know they're going up. I know it looks like a lot of money, but it is nothing in the big scheme of things. If you're looking at what long-term care costs month after month, year after year, that's in the hundreds of thousands of dollars, far more than the premium, your annual premium. In Washington State, which is what we're talking about today, is Washington law. There's also something called the Washington CARES Act, which has a modest benefit, but it's really not in place for people to collect on right now. So I'm going to skip by that. Some people have available to them veterans benefits. That's one way to pay for long-term care that may not require any spend down. There's a couple of different programs, aid and attendance, and then there's also a program which is non-means tested for people that have a service-connected disability. So if you're a veteran, you're going to want to explore what veterans benefits might pay for your long-term care. Otherwise, people think, well, Medicare is going to pay for my long-term care. No, it will not. Medicare is not intended for long-term care. It's intended for your doctor's visits, your hospital visit, rehab after you've been in the hospital for some injury or some event, up to 100 days in a skilled nursing rehab, but it will not continue and pay for your long-term care after that. So don't confuse Medicare and Medicaid. Medicare is an insurance program. Medicaid is a needs-based program, not an insurance program. Medicare does not pay for your long-term care. Medicaid is the primary payer source for long-term care in our country. And most people, unfortunately, achieve eligibility because they have impoverished themselves. And that's what I want to talk with you about today. In order to understand a little bit more about Medicaid and how to protect yourself, we need to navigate through the Medicaid maze, and it truly is. Medicaid is federal law and state law. In the state of Washington, the state of Washington will have rules about how these benefits, how to qualify for these benefits. If you live in a different state, that state will have different rules for how to qualify for Medicaid benefits. It is a very confusing, complicated structure. I don't expect anybody after having viewed today and understood or been participating in our webinar today, I don't expect you to understand Medicaid's rules. I'm just hoping to get some more general understanding that you don't need to impoverish yourself. But what's really important is that you don't feel like you're on your own and you have to figure it out by yourself. Frankly, it's virtually impossible to understand Medicaid on your own. Most attorneys do not understand Medicaid. Many elder law attorneys do not understand Medicaid, but there are a lot who do. And if you are in a state that is not Washington State, I am going to ask that you consult with an attorney in your state, an attorney who is an elder law attorney, an attorney who is a member of the National Academy of Elder Law Attorneys. And we'll put that in the chat. It's NAELA.org. That is a national association of attorneys who are dedicated to elder law practice. And they, at that website, NAELA.org, NAELA.org, there is a Find an Attorney button that you follow, and then put in there what your zip code is or what the city is, and find an attorney that is local to you. Because if you are in a state that is not Washington State, your laws or the rules are going to be much different probably than what we're going to be talking about today. So get that help of an elder law attorney, because as you'll see, there's a lot of really good reasons to consult with an elder law attorney, primary of which is that you do not want to become impoverished. And there are many ways to avoid impoverishment by seeking the help of an elder law attorney. There are a lot of differences depending on the state that you're in. We are going to be talking about Medicaid asset preservation strategies, which is the term we use here at ELG, estate planning. We're going to be talking about how married persons can avoid Medicaid Spenddown completely. We're going to be talking about single people and what can they do to avoid impoverishment, to avoid spending down. Quite candidly, single people have fewer tools at their disposal. That is because Medicaid has a policy to avoid impoverishing the spouse of a Medicaid spouse. So because of that policy, a couple can keep more money than a single person can. That doesn't mean that there's no hope, single people. There are tools that are available, just not as many as if you were in a married couple situation. And when I say married couple in the state of Washington, that also includes registered domestic partners as well. So what is the correct Medicaid asset preservation strategy for you? It completely is dependent on your unique situation, what the care needs are, where the care is delivered, at home or facility. What is your family situation? what is your asset level. And so what I'm going to be talking about is more general knowledge. I can't give anybody specific legal advice, obviously, through a webinar, but I can at least hopefully prompt and give you enough information that you seek out expertise. You seek out some attorney who does Medicaid planning for you. If you've heard me talk before, one of the things that you will definitely hear me say again and again and again is, in order to do a lot of these Medicaid asset preservation strategies, you need to have foundational, fundamental estate planning documents in place. The reason for that is that if you get to a point where you have lost capacity and you don't have the necessary estate planning documents that give authority to take action, then there's really little that an attorney can do. You'll probably be under a court-ordered guardianship, and a court-ordered guardianship is going to be far less likely to allow any of these strategies to be implemented, leaving you at a point where you're basically going to be spending down. Important is the estate planning documents. And I've talked a lot about that in a lot of different videos. I encourage you to take a look at those. If we have time today, I will try to hit on the highlights toward the end of our discussion, but I don't want to take time right now. I really want to dive into, okay, tell me about Medicaid. What is Medicaid? What do I need to know about Medicaid? So in the state of Washington, and here's your primer or your primer, depending on how you want to say it, about Medicaid. In Washington state, there are rules for how do you qualify for Medicaid. As we mentioned already, it's a state and federal program. In Washington, we refer to it as the Apple Health Program. Medicaid in Washington covers care at skilled nursing facilities, assisted living facilities and memory care, adult family homes, and even care in your own home, which is where most people want to stay. And Medicaid, Apple Health in Washington can support your desire to stay home. Now, to qualify for Medicaid, you need to meet certain tests. Remember, I said it is a needs-based program, not an insurance program. To qualify for Medicaid in the state of Washington, you need to be medically eligible. You need to meet the income test, not have too much income. We'll talk about what that is. And you need to meet the resource test, meaning not have too much money or too many countable resources. And we'll talk about what's countable and what's not countable. So the medical eligibility usually isn't that difficult. It is, if you need care because you need help with activities of daily living, for example. You need help with standing up out of the chair, with walking, with dressing, with toileting, with eating, with all those things that when you're independent, you do without even thinking about it. But as you become more dependent and as your care needs increase, you might need somebody to help you with that. And as your care needs increase, you might need to move from your home to a facility-based care, an adult family home, for example, which is probably my favorite recommendation for folks who actually need more care than they can get in their home. Skilled nursing obviously is the very high level care. And that is where people don't want to go at all, but sometimes they have to go there because that's the only place that they can be safe and the care that they need can be delivered there. So how do you know? I'm just going to take a brief aside right now to step back and say, how do you know where you should be receiving care if you need care? Or if you're caring for somebody? Often in a couple situation, it's one of the spouses has said, I promised you, you never need to go to a nursing home. I'll take care of you forever. And then at some point in time, they can't. And there's a lot of guilt involved with that. And uh, what I want you to know is at that point, you're no good to somebody. If you're the caregiver and your health fails, you need to take care of yourself. And at some point, even if you promise the person that they'll never need to move out of the home and go to an adult family home or skilled nursing, sometimes that's a promise that you can't keep, no matter how well intentioned it was. How do you decide what's the right thing to do? You are not in this alone. Of course, there's an elder law attorney who can discuss this with you, but more importantly, more so, there are people who are called aging care managers. They used to be called geriatric care managers, and you can look for aging care managers where you live. These are people who have expertise in helping with providing care. Not that they are necessarily providing the care in your home or finding the people in your home. They can do that too, but perhaps they're helping you find the adult family home that suits your needs, or find the right memory care facility, or help you with a move into a skilled nursing facility, you or a loved one. I say you, and when I say you, I'm really saying it in terms of you or a loved one or a family member that needs help. Aging care managers are, I say they are worth their weight in gold. They make such a difference in someone's life when it comes to the care and where that care will be delivered. It's hard to know what is the appropriate care and where should it be delivered. The aging care manager can help with that decision so that you don't feel like you've made a wrong decision, so that you don't feel that guilt that comes with, am I doing the right thing? Rely on the expertise of an aging care manager. And yes, they are professional. That means they will charge money. That is the best money you will ever spend. There are private placement services that you don't pay. They get paid on the back end by the care facility that the person is moved to. And that is another option. So I want you to be aware of the private placement and the aging care manager. The aging care manager is somebody who will be your advocate, such if the place that is recommended is not the right place, they will help you move to the next. You never want to move more than once, though. Once is enough, right? So you don't want to have a placement that's not going to work out. Also, an aging care manager can help you when it comes to understanding the facility's private pay requirement. So sometimes I meet with clients and there's a easy Medicaid plan to qualify for them for Medicaid, just like that. And the problem is that where they are located, the facility has a private pay period that is 2 years or 3 years. Some facilities will never accept Medicaid. And usually those kinds of facilities won't allow somebody in because they know that they're going to run out of money. But an aging care manager can help negotiate a shorter private pay period. And if they do that, then there are ways that the attorney, the elder law attorney, can qualify the person for Medicaid without having to go through the Spenddown that a 3-year private pay period would cost. So aging care managers are going to help you get the right placement, the right care, be your advocate, and help get the shortest private pay period that the facility is going to offer. I always tell clients that Medicaid comes second. The care comes first. We never let a Medicaid plan drive a care plan. The care plan always drives the Medicaid plan. So as you can well understand, the most important thing is to know that you or your loved one is getting the right care. And once we know that, then we can put a Medicaid plan in place. But do keep in mind that an aging care manager, also known as a geriatric care manager, are an excellent resource to help you if you are facing, you or your loved one are facing long-term care needs. So we were talking about Medicaid and the Medicaid maze and understanding it. And I appreciate your indulgence while I talked about the care piece, because the care piece is so important. So you're medically eligible and you know where your care is going to be delivered. Great. Next steps. What are the next steps? Are you financially eligible? Financial eligibility looks at two different things. First, what is your income? So income typically is not a disqualifier, surprisingly. Some people think it is. It depends on the Medicaid program. We have different Medicaid programs in Washington state. In Washington, skilled nursing, that's nursing home, that rarely does somebody have too much money to pay the $14,000 bill. When I say too much money, I mean income. So usually income, if you have more income than the cost of the facility at skilled nursing, you don't need Medicaid. So we're not going to be having a conversation. You have more income than you need. That's not the normal situation. In Washington state, there are programs that provide and pay for long-term care, not just in a nursing home. So what if you want to stay at home? Or what if you want to be in an adult family home or memory care or assisted living? That will be under either the COPES program. COPES stands for Community Options Program Entry System, or it'll be under the CFC, Community First Choice Program. They have different income standards and different rules. They're a lot alike, but they're a little bit different in some important ways. So the Community First Choice Program has a much lower income threshold. $943 per month is all you can have if you want care in your home under that program. That's a pretty low standard. Keep in mind, your spouse, if you're married, your spouse's income doesn't count towards these eligibility requirements. If you are under the Community First Choice Program and you are not in your home, not in a skilled nursing, because Community First Choice doesn't cover skilled nursing, but in an adult family home, assisted living, or memory care, then $2,829 gross is the income limit, not net, gross. So that's important to know that if your income is below that, then you're eligible income-wise from the Community First Choice Program. It's also called a categorically needy income level or medically needy. So a lot of people, having heard what I just said, think, oh, wow, my income is way too high. I don't know what I'm going to do because the adult family home costs $8,000 and my income is $4,000. I'm short $4,000 a month. I don't qualify from an income standard. That's not true. Let me explain why. Under the COPES program, a person who qualifies for that income-wise can have, listen to this, $11,584 per month income and qualify for the COPES program. I can tell you that if your income is that high, nearly, well, over 11,000 a month, you may not want to qualify for Medicaid because you have plenty of money to pay for your $8,000 adult family home. Whether or not Medicaid is a good idea for you is something that you talk about with your elder law attorney. What I want to convey is that the COPES program in Washington has a very high income threshold. So keep that in mind. Your income is $6,000 a month. I don't care what your spouse's income is a month. You might care because you might want to say, I don't need Medicaid because my spouse makes $10,000 a month. We've got plenty of money. Great. Don't use Medicaid. But let's say your income is $6,000 a month. Your spouse has $2,000 a month. That's $8,000 a month. The adult family home is $8,000 a month. You might want to consider qualifying for COPE's Medicaid, because if you don't, your spouse has no money. They have no income. So it might be appropriate to qualify for COPE's for that adult family home. So those are the income rules. Moving on to the other resource test, the other financial test, which is resources, countable resources. And this is where it gets a little bit complicated. So there are different types of resources. One is called countable and one is not countable. So we'll talk about what's countable and what's not countable. But if you are a single person, you are allowed to have $2,000 in countable resources. And that standard has not changed since 1989. That is truly an impoverishment standard. So single people, don't give up. There's still are some things we want to talk about later on here, but a single person, countable resource, you cannot have much money. There is this little odd tweak to our current law that says if you're under age 65 and you're not on Medicare and you need skilled nursing care, there's no resource standard. You heard me right. So you're 60 and you need to go into skilled nursing because you were just in an accident and you have $1 million in resources, you qualify for Medicaid. So that is just kind of an odd thing, and I don't expect you to remember that, but what I do want you to remember is if something happens to you, or a loved one, see an elder law attorney who knows Medicaid, because there might be some exception to a rule that provides for Medicaid for you. All right, so that is for a single person. If you are a couple, and all we're talking about right now are countable resources. So if we're talking about a couple, what can you keep? Well, you can keep more than a single person, and it depends on where the care is going to be delivered. So if you are needing care at home, or if you need care at assisted living, adult family home, or memory care, the couple can keep $70,000 basically. There's something called the community spouse resource allowance, and that's $68,301. And then of course the Medicaid spouse can keep $2,000. So 68 plus 2, they can keep $70,000. If the Medicaid spouse needs high-level care, skilled nursing care, they can keep basically it's $156,000. The Medicaid spouse can keep $2,000 in countable resources, and the Medicaid, not the Medicaid spouse, but the community spouse, the well spouse, they get to keep a community spouse resource allowance of $154,140. These are not numbers I make up. These are federal numbers. In Washington, we have kind of an interesting rule that says to keep that maximum amount of $154,000, you need to have twice that amount in countable resources when your spouse went into care. Like, huh? You needed to have twice that? Yes. That's the only way you get to keep the $154,000 higher resource limit. So, for example, your spouse goes into the nursing home. When the spouse goes into the nursing home, you have $400,000, both of you, in countable assets. Can you keep half of that or $200,000? No, you only can keep $154,000. If you have $300,000, you can keep $150,000. If you have $200,000 in countable resources, you can keep $100,000 in community spousal resource allowance. It is just a weird rule that we have that says you can keep half of it if at the time your spouse went into needing care, you had twice the amount. That's what our rule is. It's not an impoverishment program, but it's not like you can keep all your money. You can keep up to 154,000 plus $2,000. One of the things I want you to know is that once the Medicaid spouse qualifies for Medicaid, the resources of countable resources of the community spouse are irrelevant, meaning they can go up and up. They can win the lotto. They can inherit money. They can have $1 million. It does not interfere or impact the Medicaid spouse's eligibility. That's what the countable resource standard is. So what's not countable? Let's have some good news here. What is not countable is your home. If you live in your home, or if you're single and you intend to return to your home and you make that statement, your home is not countable. For a single person, it's not countable as long as your equity in it is no greater than $1,071,000. If you are a married couple, you don't have an equity limit on your home. As long as one of the spouses, the well spouse, lives in the home, that home can be worth $2 million or more. The home is an exempt resource. It doesn't count. It doesn't interfere with Medicaid eligibility. Other non-countable assets will include your personal property, a single vehicle, a life insurance policy with a face value of $1,500 or less. That's pretty small. Burial plots, cremation, an irrevocable prepaid burial plan, all of those things. If you have a long-term care partnership policy, you get to keep more money dollar for dollar for what that policy provides. So for example, let's say your long-term care partnership policy pays out $100,000, you get to keep an extra $100,000. So there are rules about resources that can be very favorable in terms of what can you keep so that you are not impoverished. One of the most important rules about what is not a countable resource has to do with what is called a Medicaid-compliant annuity. It's also called a SPIA, single premium annuity. It is not annuity that you have, even if your financial advisor recommended you have annuities to replace income streams, it's not an annuity you have unless you did it as a part of a Medicaid plan. Why is that? Because these are not favorable annuities for investments. These are annuities that allow you to take what is countable, cash, make it non-countable, put it into a Medicaid-compliant annuity. There are very special rules, especially in the state of Washington, about this annuity. It has to be irrevocable, non-assignable. The term of the annuity will be 5 years or less if the life expectancy of the annuitant is less. And here's the kicker. The state of Washington is named as the beneficiary after the annuitant, such that if the person, the well spouse, for example, who bought this annuity, if they die during the 5-year term, then the annuity now pays to the state of Washington up to the amount of the benefits that were paid for the ill spouse when the well spouse died. And after that, the rest of the annuity can pay to the kids or whomever the remainder beneficiaries are. So see why I say that if you have an annuity, you don't have a Medicaid compliant annuity unless you've applied for Medicaid, because it would make no sense to name the state of Washington as that next beneficiary under your annuity. But it is a very important planning tool, and we'll talk about why that is. So our topic today is the Medicaid maze. We have talked about various programs, how to qualify from a medical and income, and what is a countable resource and how much can you keep. So let's say you've just got more countable resources than what those limits are. What are you going to do? Here are some recommended spend down. I'm not saying you have to, but I'm saying here are some smart spend down options. Buy an exempt resource. For example, if you have a mortgage on your house, well, that's paying off a debt, pay it off. take down your liquidity, turn it into an exempt resource. That is your house. You could even buy up. You can buy a bigger house if you want. It's not commonly done, but it is an option. You can trade in your old car, buy a new car. You can buy anything else that you need personally, or you can buy that Medicaid-compliant annuity. We'll talk more about that. Pay for legal services, pay for caregiving services. You can pay for those things that are needed, not gift. Don't gift. Pay for things that you need. If you're a spouse, pay for things that your spouse needs. Pay for things that make your life better. You can pay for a family caregiver. Let's say that your son comes in the home and helps take care of you so that you don't need to move out of the home. You can pay that your son for his caregiving to you. Just make sure that you do it in the proper way, which of course Washington has its own rules. There should be a documented need for service by the physician. You can't pay him way more than you would pay somebody else. Like if you're paying a caregiver $30 an hour from an agency, don't pay your son more than $30 an hour. And you can't wait. You have to pay them right away within the month that the services were provided. The reason that the state has this rule is you can't say, oh, my son took care of me for the last 5 years, I'm going to give him $200,000. That's not going to fly. That's not going to work. That's going to be considered an improper payment and a gift, and it's going to interfere with Medicaid eligibility. But here are some ways to spend your money wisely. At some point, you're going to say, well, I don't want to do a spend down. I spent down everything that made sense. We'll talk about other strategies then to avoid spending down money you don't want to spend down. One of those, something that I want you to be aware of, is there are some transfers, meaning gifts, transfers of assets for less than fair market value. That's called a gift. You can gift in certain situations to preserve that asset and not have a problem with Medicaid. So for example, what can you do? There's a basic rule that says if you gift within 5 years, Medicaid cares. They want to know, why did you do that? If you gift beyond month 61 before you apply for Medicaid, Medicaid doesn't care because there's a 5-year look back window. So anything you do 5 years before you apply for Medicaid doesn't matter. So let's say you do make gifts, monetary gifts, or some sort of gift. I want you to be familiar with how Medicaid treats that. So transfers of assets under the normal rule within 5 years are penalized, meaning there is a period of ineligibility for benefits, which doesn't start until you're otherwise eligible for Medicaid. Our current rule, we're at the end of 2024 right now, the penalty divisor for a gift is $12,842. So for every $12,842 you gift, 1 month period of ineligibility. So for example, you gift $150,000, that's an 11.68 month period of ineligibility, which doesn't start running until you are otherwise eligible for Medicaid. And what's really important is if you gift your money away and then you apply for Medicaid because you have no money, you have to show that you have a way to pay for your care during that period of ineligibility of 11 months, for example. So that is not something that's easily done. That really requires some strategic thinking. We'll talk about that. We'll talk about intentionally gifting and some strategies that work very well. But before we do that, let's talk about transfers which cause no penalty. So this is good news. You can give away some of your assets and Medicaid won't penalize you. Yes. Remember, beyond the 5-year look back, no penalty. You can also transfer your home to a qualified beneficiary. First of all, if you're married, your estate elder law attorney will transfer the home to the well spouse to avoid the state's estate recovery. So that is a no-brainer. But you can also transfer your home. Oh, let me back up. Transfers between spouses are not penalized because you're spouses. And because you're spouses, Medicaid counts what you both have, regardless of whether you think it's yours or theirs, separate or community. Medicaid doesn't care. If it's in the name of one spouse, the other spouse, it's combined. So that's the reason that transfers between spouses don't matter, because in terms of, because the state doesn't care who owns what. They say the two of you own it, we count it. Why we transfer assets from an ill spouse to a well spouse is so that when the ill spouse dies, for example, then the state has no right to recover against that asset because it's not owned by the ill spouse. That's avoiding estate recovery. All right. So what transfers cause no penalty? Transfer of the house to the spouse, transfer of your house to a disabled child. Your disabled child could be your 55-year-old son who has a back injury from being a labor, having hurt himself on the job, and now he's on SSDI because he can't work because of his back. You can transfer your house to him, no penalty. You can transfer any asset to him, no penalty. You can transfer your house to a sibling, if your sibling has an equity interest for a year or greater in their house. You can also transfer your house to your caregiver child. Your child lived with you in your house for 2 years and provided care so that you did not need to seek Medicaid benefits. Be very careful with this transfer. Do not do it on your own, because there's this one special rule having to do with the caregiver child transfer that says if you do it, if you give your house to your child and then go on Medicaid, it must be immediate. You cannot have any private pay period. And many facilities have a private pay period. If you have a private pay period, that ruins the transfer option, and it's a penalized transfer. So, for everything I'm talking about, please don't try this on your own. An elder law attorney is going to be necessary to help you do this right. Other transfers that cause no penalty to, as I mentioned, a disabled child, or you can do it to a trust for a disabled person. There's actually ways to transfer your own money if you're under the age of 65 to a D4A trust, no penalty. That's a D4A trust is a trust that's allowed for people that have too much money to qualify for government benefits. So there's a special type of trust where you can transfer all your assets to that trust. That is something that is often done when people have been in a big personal injury type situation and they recover money. They'll create a D4A trust. The thing about a D4A trust is that there is a payback to the state upon the beneficiary's death. So that is a whole different topic, but I do want you to be aware that you can transfer to a D4A trust. And then, of course, transfer assets after you're on Medicaid that cause no penalty or no problem. For example, the car. Your car can be transferred after you're on Medicaid, and there's no penalty for that. If you recall, I mentioned a program called Community First Choice, CFC. That program is the one that had the lower income amounts for care at the home, 943, or care at a assisted living or adult family home, 2,829. So if your income is below those thresholds and you're looking for a plan to preserve some of your assets, so you don't have a disabled child, or none of those exceptions work for you, but you just want to make sure that everything you've worked so hard for doesn't have to be spent down, and your facility will take Medicaid, and you want it to go to your family, for example. The Community First Choice program doesn't have a transfer penalty. You can transfer assets, no penalty, and receive state benefits to pay for your long-term care, Medicaid benefits to pay for your long-term care. So that's always one of the things that we look at when we're helping clients figure out what's going to be best for them. So the CFC program transfers with no penalty might be the appropriate thing. Of course, there's risks with that. One of the risks are that the person who needs the care moves to a skilled nursing facility. CFC does not cover skilled nursing. So whomever received the gift has to give all that money back to pay for the care, or another strategy has to be implemented. And if they don't, there's 150% penalty for the person who received the gift if there's a hardship exemption and Medicaid needs to pay for the care and the gift hasn't been returned. So these sorts of Medicaid strategies are not entered into lightly. Whomever is doing it needs to understand the risk associated with it. And who is going to explain that to you is your elder law attorney who understands Medicaid strategies. So once somebody is on Medicaid, really important that they don't keep any assets in their own name. The reason for that is if they die with assets in their name, so a single person can qualify for Medicaid with a house, but if they are on Medicaid and then they die, who's going to get the house? The state's going to get the house, at least to the extent of the benefits that were paid for the person who died. For couples, really important, move all the assets from the ill spouse over to the well spouse. How do you do that? Hopefully you have those good, fundamental, foundational estate planning documents that allow those transfers to occur. So at 1 year, there's going to be an eligibility review, at which time the Medicaid spouse or the Medicaid client can't have too much money. They all have to be transferred to the well spouse if it's a community situation. So who does this? Your elder law attorney helps you make these transfers. And by doing that, you can avoid Medicaid estate recovery. If you haven't taken steps to avoid estate recovery, there will be Medicaid state recovery. In terms of a couple, the state doesn't enforce the recovery until the well spouse has died. Also, if there's a disabled child, then the state will not enforce that recovery. So if you're in a situation where somebody has died and you're trying to figure out whether or not you have to pay back the state for benefits from that deceased person's estate, you'll want to see not just an attorney who does probates, but an attorney who does probates and understands Medicaid as well. Thanks for sticking with me. We are going to be talking about Medicaid estate asset preservation strategies. First for a married couple, then for a single person. For a married couple, we are going to be talking about a very simple strategy that they can implement while they are both alive to keep all their assets. For a single person, we are going to talk about a couple of strategies. Single people, for example, can do a 5-year look-back trust or gift, or they can do time of need planning, which surprises a lot of single people. They don't think that they can do anything at the time of need, but they can. So for a married couple, let's say that they have a house that's worth $400,000 and they have $400,000 in bank accounts, which is a total of an $800,000 estate. Now remember, the house doesn't count against them because it's exempt. So all we have is $400,000. And this couple, especially the well spouse, doesn't want to see all their money be spent down on their spouse's care, because then what are they going to have to live on when they are the surviving spouse? They do not have to spend down that money. In this example, the ill spouse goes to a skilled nursing facility. At a skilled nursing facility, remember, the community spouse, the well spouse, can keep $154,140. Okay, they still have too much money. They have $400,000. They have $245,860. Too much. Can they spend it down? Of course they can. Do they need to spend it down? Absolutely not. Take that money and buy that Medicaid-compliant annuity. remember that takes countable assets, money, 245,000. The well spouse buys the Medicaid-compliant annuity with that 245,000. And over the course of the next 5 years or 60 months, that annuity will pay back month by month by month to the community spouse, the well spouse, 4,000, basically $4,100 a month. That money all comes back to the well spouse, meaning that this couple with 400,000 in the bank doesn't need to spend it down. They convert it from countable to non-countable, what they need to, and then it comes back to the well spouse. So if you are in a couple situation, keep in mind that if your spouse is going into care, you'll want to see your elder law attorney. Hopefully you know who your elder law attorney is because they prepared your estate planning documents in advance. As long as the couple has capacity, each of them, the documents can be prepared at the time of need of long-term care. But that's really risky, isn't it? Waiting until somebody needs care and they may or may not have capacity. The documents, the estate planning documents, should be in place well in advance. And also the benefit of that is when your spouse needs long-term care, you know who to turn to because you worked with an estate planning and elder law attorney with Medicaid expertise. So you don't have to switch attorneys when everything is in crisis. You go back to your attorney who knows how to implement these strategies. For a single person, what do? You know you have assets that you want to protect. You can give them away while you are still healthy. Now, giving them away means to an irrevocable trust of which you cannot be the trustee or the beneficiary, or it could be gifting it outright. Keep in mind that this is a pretty drastic action to take. We do not recommend that unless it makes sense. For example, maybe the person has a diagnosis that they know in 5 years they will be going into care. Or maybe it's a situation where even if they don't have a diagnosis, they have this legacy property, the family cabin, the family farm that will always be kept in the family, for example. So they're not so concerned about negative tax consequences of moving an asset into a trust or gifting it. So what is going to be the right situation depends on what your desires are. Maybe you are just very concerned, you worked really hard, you don't want your house to be lost. And so you'll say, I'll put my house into an irrevocable trust for my son. I know since I am not the beneficiary of this house, I need to pay rent on the house. And I can't be the trustee, and I'm not the beneficiary. My son is, but I've given him the house and I'll pay rent. I do that 5 years in advance. That could be an effective Medicaid strategy. Again, it's a pretty drastic one. So there are other strategies. For example, at time of need, let's say the person didn't do anything they're single, they didn't do anything what I just talked about. I'm going to explain what we call a half-a-loaf strategy. It's just a terminology. What it is a single person, they haven't done any planning except for they have good estate planning documents, which is great, but they didn't do a 5-year gift or Medicaid trust gift 5 years in advance. So they need care. They're going into care, adult family home. It costs $6,000 a month. Their income is $3,000 a month. So their shortfall is $3,000 a month. They have a house. Let's say the house is worth $320,000. Let's say bank accounts down to 60. Maybe they privately paid at this adult family home, such the adult family home will now take Medicaid. I don't know, but let's say that they spent down, and in my example, they have 60,000. So in order for a single person to qualify for Medicaid, they can only have 2,000 in the bank. So they're going to have to spend down some more. They'll spend 15,000 to ready their house for sale, for example. They'll buy a new car, $20,000, trade in their own, 20,000 to get a good car, 5,000 to buy an irrevocable prepaid burial plan, and then they'll spend the rest of the money on legal services and care. So once that person is down to 2,000, They apply for Medicaid and they're on Medicaid. What are our next steps? We sell the home. At that point in time, the home is sold to avoid the state getting it in estate recovery. So let's say the home, which was worth $320, it nets $300 on the sale. What are we going to do with that $300,000? Well, the client is going to gift $240,000 to their responsible adult child. They're going to keep $60,000. We tell DSHS, the Medicaid agency, everything that we just did. What will DSHS do? They're going to impose a period of ineligibility of about 19 months. How do they determine the period of ineligibility length? They take the $240,000, divide it by the penalty divisor, $12,842. It's a 19-month period of ineligibility. What does the client do? They're off Medicaid for 19 months. Remember, they were short $3,000 a month. They take 19 months times 3,000. 57,000 is how much money they need to get through that penalty period. And they have it because they kept 60,000. When they're down to 2,000 again, we apply for Medicaid. They're back on Medicaid again. What is the net result? The care hasn't changed, but what we have done is we preserved assets, $240,000 plus the car, which can be gifted with no penalty either. So a very significant savings of money that this person had worked for and wanted to make sure that their family could benefit from, all without jeopardizing their care. So I said we would go over estate planning documents if we had time. We don't have time. We can certainly cover estate planning documents, the fundamentals, and especially those that are needed such that strategies like I just described can be implemented, particularly where the person whose assets we're trying to protect no longer has capacity to make these decisions on their own. Having the right durable powers of attorney with the correct authority in it. For a couple, having a will with an asset protection supplemental needs trust in case the well spouse dies first. These are critically important. So we'll talk about that another time. I'm just looking to see if there's questions and answers. So one of the questions, can we put assets in trust and be exempt from Medicaid Spenddown? I think I just described that. Yes, as long as you do it 5 years in advance and as long as you don't appoint yourself as trustee or beneficiary. Trigger standards, income trigger standards in the chat. You know, we are going to be sending you it's a several page document with all of those standards and information. So it'll be coming your way. Gift rules, dollar triggers, all of those you will be receiving. Husband needs to go to skilled nursing within a year. Understood. Can't care for the home and the property, like to rent an apartment. When it comes to using your home, not for yourself, but as a rental, that is problematic, and you'll need to see an elder law attorney because that does not fit within the rules. IRAs in the state of Washington are 100% countable, as IRAs in particular. 401ks, there might be an exception if you can't access it, but that's for people who are still working. Yeah, retirement accounts count. And you are definitely going to be able to rewatch this. We do like to make sure that it gets sent out to the attendees, and of course will be on our YouTube channel. And kind of a plug for our YouTube channel, please, if you like what you're seeing, give us a like, subscribe, share this information with your friends, with people you know. It is really important to us here at ELG Estate Planning that we share this information and share it with people who are in different states. That may prompt them to see an elder law attorney where they live so that they can avoid unnecessary spend down and impoverishment. That pretty much covers it all today, all that we have time for. Thank you so much for taking precious time out of your day and sharing your time with me today. And thanks again. We'll see you next time.